on June 14th, the U.S. Citizenship and Immigration Services released new policy guidance on the eligibility criteria for initial and the renewal applications for employment authorization documents for something new. It's called compelling circumstances. So there's now a whole new group of people who may be eligible for work permits. Now, this is the group. For the applicant to be eligible for the new work permit based on compelling circumstances, got to meet the following requirements. The principal applicant and their family members, but would be all eligible for the work permit, but you have to qualify based on the principal applicant. The principal applicant has to be the principal beneficiary of an approved I-140 visa petition, which is the immigrant petition for alien worker, and be approved either in the first, second, or third preference employment-based category. So that would be your EB1 workers, your E2 workers, your EB3 workers, not your special immigrant religious workers under 4, and not the investors under EB5. So it's EB1, 2, and 3. And the principal applicant has to have that I-140 approved and also be in valid E3 status, H-1B status, O status, or L status. And then they can file a Form I-765. And the principal applicant also has to show that no adjustment application has been filed. Who is this going to help? It is going to help people who got sponsored in jobs for their green cards but can't file their adjustment of status yet because the priority dates have not been reached. Now, you got to show an immigrant visa is not available to the principal applicant based on the applicant's priority date, according to the final action date in the U.S. Department of State's Visa Bulletin. And as I said earlier, also family members, spouse, and children also can qualify. And if immigration determines in the matter of discretion that you have compelling circumstances to justify the issuance of a work permit, even though you have not filed your adjustment of status application, you and your family can get work permits. Now, this guidance covers compelling circumstances for the principal applicants and, as I said earlier, their dependents, the spouse and children, and provides a list of situations that could lead to a finding that compelling circumstances exist, including serious illness and disability, employer dispute or retaliation, or other substantial harm to the applicant or other significant disruption to the employer. And this guidance also provides details on evidence an applicant could submit to demonstrate compelling circumstances. For example, a principal applicant with an approved immigrant visa petition in an oversubscribed visa category or chargeability area who has lived in the United States for a significant amount of time could submit evidence such as school or higher education enrollment records, mortgage records if they own a home, long-term lease records to support a potential finding of compelling circumstances. Compelling circumstances could include if, due to a job loss, the family may otherwise be forced to sell their home for a loss, pull their children out of school, or even relocate back outside of the United States of America. This is especially going to help people in oversubscribed areas, Philippines, Mexico, India, and China, but all oversubscribed employment areas. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.